Straight ahead, all Law&Crime Daily. The trial of an Iowa college student found murdered in a cornfield begins. Why defense attorneys for Cristian Bahena Rivera are focusing on Mollie Tibbetts' boyfriend.
You'd had a relationship with a woman other than Mollie, right?
Correct.
Accusers take the stand against that 70s show actor, Danny Masterson. One woman's account of the alleged rape. And the brave 11-year-old who fought off an attempted kidnapping. Plus, defense attorneys for Robert Durst tell the jury he discovered his best friend's body but didn't murder her.
If not Bob, it's...
The trial of Cristian Bahena Rivera has begun. He's accused of murdering college student Mollie Tibbetts. Angenette has the latest.
Yeah, Brian, prosecutors say the evidence in the murder of Mollie Tibbetts points squarely at Cristian Bahena Rivera. They say it's his own words and the physical evidence that shows that he committed the murder and no one else. Now, prosecutor Bart Claver told jurors that Tibbetts went out for a run on the evening of July 18, 2018, and never came home. Tibbetts' friends, family, and law enforcement launched a massive search for her, and even the FBI was involved. Then Claver says a piece of surveillance video surfaced that showed someone jogging in a black Chevrolet Malibu with distinctive features circling the area. That led investigators to Cristian Bahena Rivera at a local farm where he lived and worked.
And he admitted that he had seen Mollie the night she disappeared. He admitted that he found her attractive, that she was hot, in his words. And he admitted after he saw her the first time, he circled back to take a second look. He admitted that he followed her, that he got out of his car. She threatened to call the police, and he admitted he became angry at that time. He admitted to fighting with her. And then he says the next thing that he remembers, he's driving in his car, and he notices Mollie's earbuds. And he remembers that Mollie is in his trunk. He admits taking Mollie's body out of the trunk. He admits seeing blood on Mollie's body and neck. He admitted taking Mollie into the field, placing her face up, and putting corn stalks on her body, and then leaving.
Now, prosecutors say that DNA testing showed that the blood in Bahena Rivera's trunk belonged to Mollie Tibbetts, but the defense has disputed that in court documents. Meanwhile, the defense declined to give an opening statement at this time. They will do that later on in the case. So the state called its first witnesses. The first one was Blake Jack, and his brother Dalton was the second witness. Dalton was Mollie Tibbetts' boyfriend at the time of her death. They were living in Blake's home for the summer, and Mollie was watching the dogs since Dalton and his brother Blake were out of town for work. Dalton testified about the last time he communicated with Mollie, while the defense laid the groundwork to point the finger at Dalton for the murder.
I had Snapchatted her, but she had not replied.
Okay. So, do you remember when you sent her a Snapchat?
I don't remember the exact time of when I sent her a Snapchat.
Okay. What time would you have gone to bed on July 18th of 2018?
Relatively early, granted how early we woke up in the morning.
All right, and did you receive a Snapchat from Mollie that evening?
Yes.
Yeah. When did you actually open that Snapchat?
The next day.
You'd had a relationship with a woman other than Mollie, right?
Correct.
Who was that woman?
Her name was Jordan Lamb.
What did you tell officers the reason you withheld that information?
I didn't deem it necessary.
You didn't deem it necessary?
I didn't think that it was pertinent to the case.
Now, on cross-examination, Dalton Jack conceded that Mollie was actually thinking about breaking up with him in the weeks before the murder. And he said he was not happy about it. He was angry, and that Mollie was thinking about moving in with friends. But prosecutors say that Dalton Jack actually cooperated with testifying in this criminal trial. He didn't want to come here, though. He said he didn't want to be in the same room with Cristian Bahena Rivera. Brian?
Thanks, Angenette. Joining us today is founding partner of CHR Law Group, defense attorneys Caesar Chikuma and Terri Austin. Caesar, false confession and arguing against DNA evidence. What do you make of the defense's decision to not give an opening statement at this point?
Well, whenever it comes to DNA or scientific evidence, that is the hardest type of evidence to overcome. Typically, how that's done is later on in the case by attacking the methodology and bringing your own experts. As far as the false accusations and the confession, we have to remember here, the defense has to try and attack the confession, basically saying that it was coerced and involuntary. Again, that's later on in the trial. However, the defense, in waiving their opening, that is typically a trial strategy and tactic, so you don't reveal to the other side your defense and specifically what it is you want to do. Now, however, the problem with that is you don't want to wait too long to show the jury what you believe the facts and evidence will show in a case.
All right, so we'll see if this tactic plays out. Maybe they'll give an opening statement later on. Terri, what's the linchpin in the prosecution's argument here?
I think the prosecution did a very good job. It was succinct. He told the story, but he asked the jury to remember three things. He said he wanted the jury to think about the video. Angenette mentioned that there is a video and it shows Mollie running on the street, or at least an image, and it also shows the defendant's car. So the prosecution also said they want the jury to remember Mollie's blood. It was found in the trunk of the car. That was the second thing. And the third thing was the fact that the defendant admitted so much. He admitted that he was, following her. He admitted that he thought she was quote unquote hot. So the prosecution, I think, is focusing on those three areas.
It makes a lot of sense. Really holds the case together. Angenette, we expect to see the evidence soon that led the investigators to Bahena Rivera, right?
Yeah, exactly, Brian. We're expecting to see that surveillance video that shows what's been described as a silhouette of a person jogging along the road that night in that very distinctive vehicle. The prosecutors say that it's a black Chevy Malibu with chrome covering over the windows, and they say that's something you just don't see a lot. So it'll be interesting to see that exact piece of video and how it led the investigators to Bahena Rivera.
Absolutely. Still ahead on Law&Crime Daily, a star from the hit series That 70s Show is pleading not guilty to rape charges. Plus, the shocking video of an attempted kidnapping and the amazing 11-year-old girl who was able to fight off a grown man you don't want to miss. Welcome back. Danny Masterson is pleading not guilty to sexual forcible rape charges. This comes as one of his accusers testifies that she woke up to find the That 70s Show actor assaulting her. Danny Masterson is accused of raping 3 women in his home between 2001 and 2003. Jane Doe number 1 took the stand at a probable cause hearing in Los Angeles. She says she was friends with Masterson through the Church of Scientology. On April 25, 2003, Jane Doe 1 says she went to pick up keys from Masterson's house. She claims he gave her 1 drink with vodka in it, then began to feel blurry and queasy. That's when she says Masterson threw her in his jacuzzi. His friend picked her up because she couldn't walk, and Masterson carried her up to his bedroom. She described Masterson touching her as she lost consciousness, too weak to fight back. She says he raped her on his bed, but only has flashes of memory. In between tears, she told the court, quote, "When I came to, he was on top of me and he was inside of me. The first thing I recall is grabbing his hair to pull him off." She also claims Masterson pulled out a gun and threatened her. On cross-examination, Masterson's defense attorney asked why hadn't a gun been mentioned in her original police report. The defense also asked her about a settlement and non-disclosure agreement she's reported to have reached with Masterson. The woman says the Church of Scientology pressured her not to report the rape, but she did file a police report 14 months later. The LAPD closed the investigation, saying more women needed to come forward to corroborate her story. 2 more women did in 2016, and Masterson was arrested last year. Outside of court, Masterson posted this photo on Instagram with his wife. The caption reads, "Had the most beautiful Uber driver drop me off at school today," tagging the courthouse as his location. The hearing's expected to last 4 days. All right, let's bring back defense attorney Cesar Chikuma and Terri Austin. Terri, this is just a preliminary hearing, so all the prosecution has to prove is probable cause. But do you see that and maybe a little more?
Oh, I definitely see probable cause here. I mean, courts usually find that when there's a reasonable basis for believing that a crime could have been committed. And here we have that. We have 3 Jane Does, and they're all testifying that he sexually assaulted them. And this particular Jane Doe, she had significant evidence as far as her testimony was concerned. She signed a police report, and she also had other information in other statements. So I definitely think that they're going to move forward here. They'll find enough evidence. Yeah.
And don't forget, probable cause is one of the lower standards in criminal cases, beyond a reasonable doubt, obviously being the much bigger one at trial. Now, Cesar, you've got a big following on Instagram. I'm sure your clients use it as well. Was this post by Masterson IMC's approved?
No. And let me start by saying I typically advise clients never to post or be mindful of what you post on social media because people are always watching. And hardly anything good comes from posting on social media, especially when you have a pending case. And often clients forget that anything you post usually can be used against you. Now, specifically in regards to this point, this post, I mean, it appears callous, it lacks empathy, and it's just, quite frankly, classless.
Yeah, we're not saying he's guilty, we're not saying he's innocent, but optics is a big thing when it comes to a case. And when you're going to a preliminary hearing, what a woman is talking about, and it sounds almost close to like a Bill Cosby-esque type of allegation that he gave her Quaaludes because she suggested she only had one drink and felt queasy and nauseous. Not sure if this is the photo you really want to show before you show up to court, but we'll see how it plays out. Now to Florida, where a local sheriff says newly released surveillance video shows an 11-year-old girl escaping an attempted kidnapping.
A white van pulled up to an 11-year-old girl, stopped the van, looked around, and then a man left that vehicle, ran towards the 11-year-old victim with something in his hand that was reported to be a knife. He grabbed her, picked her up, and tried to carry her into that van. She fought and she fought and she fought until finally she was able to break free from her would-be captor. We were able to see that van, and we also arrested the suspect. And this 30-year-old male will be charged with attempted kidnapping, with aggravated assault with a knife.
So thankful that 11-year-old girl was able to get away. Let's check in with Chief Investigative Correspondent Brian Ross with what he's digging into this week.
Thanks, Brian. Coming up this week on Brian Ross Investigates, a 21st century crime wave, tech-savvy hackers, kidnapping, taking hostage the computer systems of hospitals, police departments, and now one of the country's biggest pipelines. The Colonial Pipeline Company says it had no choice but to pay a $5 million ransom. The country's former cyber czar says that was wrong.
I don't think we can make exceptions. I think we have to make it illegal for anyone to pay these ransoms. And as soon as we do that, they will go away.
That's coming up this week on Brian Ross Investigates on the Law&Crime Trial Network. Brian?
Thanks, Brian Ross. Coming up on Law&Crime Daily, the Robert Durst trial resumes after a 14-month pause. Everything you need to know from the prosecution and defense's opening statements after this break. We're back. Prosecutors say millionaire real estate heir Robert Durst killed his best friend because she was a witness in the assumed murder of his first wife. Both sides were able to recap their opening statements, but not without a series of objections.
He didn't kill her out of hatred. He didn't kill her out of revenge. He didn't kill her because he disliked her. He killed her out of survival. He believed, and this comes from his mouth, that in the end, it was her or me. I had no choice. And what the evidence is going to show is that you can fault Mr. Durst for the murderous nature of his conduct with Susan Berman. But what you can't fault him for is, from his perspective, the necessity of having done it. The problem the evidence is going to show with the murder of Susan Berman is that Mr. Durst committed that murder about 20 years too late, because Susan Berman had already told her story to numerous people.
That in his opening, that the investigation in New York was subpar. I think that.
Yes, that was an argument, and it was, and the objection was sustained to that. Calling it subpar is a characterization. Now, saying there are other ways to go about it, it's a fine line. That's an argument.
I would just say that my memory of my statement was the evidence will show that the investigation was subpar. That's what the evidence will show. I mean, Your Honor, the evidence will show that the lead IO slept with a witness. I mean, that's what the evidence is going to be.
Very well. I mean, to me, I mean, that I noticed that one. That wasn't the one that bothered me, really. But I do think that is fairly described as an argument.
Here with us is defense attorney Cesar Chikuma and co-host Terri Austin. Terri, things got a little heated in this case early on. Do you think it will continue when Durst takes the stand?
I do. I think these attorneys have known each other for a while. They've been dealing with this case for over 14 months. We know that. I think Prosecutor Lewin is the one who is really very heated. So when he does the cross of Durst, I think we might not see as much heat because I think Dick DeGuerin, I think he is a little bit more laid back. But I've got to tell you, I think Lewin is going to go in hard. I think he's going to attack Durst. I think the judge will probably allow that to occur unless we have multiple objections. So we'll see, but they're definitely going at each other.
I mean, Lewin did say, get your candy and your popcorn and take a seat. It's going to be exciting. So we'll see how that plays out when it happens. Caesar, how do you think the judge is handling the back and forth between the lawyers?
Look, both attorneys seem extremely heated at times, and especially with cases like this, emotions are running extremely high. However, at the onset of the case, the judge really has to do a good job setting the tone not only of his courtroom, but the trial. And although it appears that he's trying to be tough, he seems extremely lax at times and seems like he's letting the attorneys get away with a lot.
Yeah, and we'll see how it goes because, I mean, it's like any, sorry to bring in sports analogies, I played soccer. It's if the ref doesn't make the right call in the beginning, later on in the game, things are getting a little reckless. We'll keep eyes on this because, of course, Law&Crime has cameras in the court. We've got gavel-to-gavel coverage in the California versus Robert Durst case. Make sure to check it out. Thank you both. When we come back, the other side of the story, was Robert Durst involved in Susan Berman's murder, or was he just in the wrong place at the wrong time? The defense's opening statements next. Welcome back. Defense attorneys for Robert Durst say he will take the stand during his trial for the murder of his best friend. They say Durst didn't kill Susan Berman and doesn't know who did it.
Bob got to Los Angeles and he went to Susan's house. The front door was locked, nobody answered. He went around to the side and the back door was open and he went in and he found Susan's body. But before he left and drove back up to San Francisco, he wrote a note, an anonymous note, and sent it to the Beverly Hills police. For years, he denied writing the note. It's so obvious, if you've ever seen Bob's handwriting, that that's Bob's handwriting. And so he'll tell you, I was afraid that she would lay there for days and nobody would find her, so I wrote that note, I sent it to the police.
The defense attorneys say this is a purely circumstantial case and that prosecutors failed to prove who the real killer is.
The evidence is lacking. The evidence will show that there was not a fingerprint of Bob found. There was not a handprint. There was no DNA. There was no blood of Bob. No gun. There is no evidence. No forensic evidence, none, that Bob Durst killed Susan Berman. Was she murdered? Yes. Who did it? That's not our burden. That's not your burden. The state's burden, the prosecution's burden, is to prove who did it beyond a reasonable doubt. It's not a process of elimination. It's not, if not Bob, who did it. It's, if not Bob, it's not guilty.
Let's bring in Caesar and Terri one last time. Caesar, call me crazy, but the defense's argument, if you can't prove the crime, you can't prove the cover-up, makes sense to me. What do you think?
You're not crazy at all. Exactly that. If you can't prove the crime, you can't prove the cover-up. The state has to present evidence, right? So here, although they're trying to use it, the disappearance of his wife, as motive for the cover-up, let's be real here. He has not been charged with the murder of his wife. We don't even know where the body is. So for them to try to use that or even be able to bring it up, matter of fact, I think it should be inadmissible.
Yeah, it seems like the foundation of their argument is somewhat shaky if it's built upon Robert Durst killed Kathleen Durst. We'll see how that plays out for the prosecution. Defense may have an argument there. Terri, was there anything in the opening statement that made you believe Durst was more than presumed innocent?
Well, you know, it's interesting. I think that the defense actually did a decent job with the statement. I think the evidence against Durst is overwhelming, but the defense had an explanation for everything, even if you don't want to believe it. He tried to make a distinction between the three individuals, obviously Kathy Durst, Morris Black, and Susan Berman. He said with Morris Black, look, Morris Black was murdered, but he wasn't found guilty there. He was just found guilty of destroying the evidence and jumping bail. So for that, he served his time. And what he's trying to say here is that Durst isn't guilty of anything else. There's no evidence against him as it relates to Kathy Durst. As we just said, there's not even a body there. And as it relates to Susan Berman, there is no forensic evidence. So I think he has a good story. I think that it's still overwhelming. I think at the end of the day, the jury's going to come back with a guilty verdict, but he's done as much as he possibly can to try to see that his client is presumed innocent until and unless the prosecution proves beyond a reasonable doubt that he's not.
Yeah, of course, the defense attorney is really holding tight to that burden of proof. We'll see how it plays out for them. Caesar, Terri, thank you for joining us, and thank you for joining us here at Law and Crime Daily. We'll see you next time as we discuss justice in America.